my research is entitled Obligations, erga omnes partes, and Standing Before the ICJ. And it is concerned with this category of obligations, erga omnes partes, under international law. The background of this research is the recent developments in the cases and jurisprudence of the International Court of Justice, in particular the landmark case in 2012 between Belgium and Senegal. In that case, Belgium instituted proceedings against Senegal and claimed that Senegal breached obligations under the Convention Against Torture by failing to properly investigate Mr. Aj.Phattharaphong, who was the former president of Chad and was accused of committing torture in Chad. Now, one of the preliminary objections raised by Senegal was that Belgium did not have standing in those proceedings because there was nothing to do with Belgium. There were no nationals of Belgium involved. And in response, Belgium argued in particular that as a state party to the Convention Against Torture, it did have standing because the obligations invoked by Belgium were obligations erga omnes partes in the sense that they are owed towards every state party to the Convention Against Torture, including Belgium. The court accepted this argument of Belgium, which is unprecedented. This is perhaps the first time that the ICJ established expressly this kind of standing, which is based simply on the status as the treaty party. So I wanted to examine this finding. I have two research questions. First, how are we to identify obligations erga omnes partes? And secondly, what are its legal consequences, particularly in relation to the standing before the ICJ? So I began by defining obligations erga omnes partes. Here, I adopted the definition as used by the court itself in the Belgium versus Senegal case, and in paragraph 68, the court explained that it used the term obligations erga omnes partes in a sense that, and I quote, each state party has an interest in compliance with them, these obligations, in any given case. So the examples of these obligations would be the obligations to investigate a person suspected of torture or to prosecute that person where there is enough evidence or to extradite them. These obligations are owed by one party towards every party, and it is in this sense that each party has an interest whenever these obligations are performed. Now, to understand this better, I put this definition in a broader context as to how we classify international legal obligations. I use the International Law Commission thinking as explained in the commentaries to the articles on responsibility of state for international wrongful act, and there the ILOC proposed to distinguish bilateral obligations from multilateral obligations on the basis of the structure of the obligations. And according to this classification, bilateral obligations are those obligations that are owed by one state party or by subject to another state or subject, whereas multilateral obligations are owed by one state or subject to multiple states or subjects. And the obligations erga omnes partes are the subset of the latter. The first question as to the criteria by which obligations erga omnes partes can be identified, I found that the process of identification is an ordinary process of interpretation. In the case of treaty, it is a normal process of treaty interpretation. I further found that there may be some treaties that expressly provide for the erga omnes partes nature of the obligations therein, but even if there's no such express provisions, I argue that we can still establish obligations erga omnes partes by looking at two elements which must be satisfied cumulatively. The first is there must be the shared values or common concern which underpin the obligation and go essentially beyond bilateral relations. Secondly, the obligation must be owed towards every party and not just one specific party. For instance, it must be triggered or apply without any link with any specific party. In the full report, I seek to show that this methodology is consistent with the long jurisprudence of the ICJ. On the second question as to standing, I first began by defining standing in a contentious case as the sufficient degree of a legal interest in a subject matter of the case. And in my analysis of the ICJ jurisprudence as well as the Permanent Court of International Justice jurisprudence, I found that international law has long recognized this kind of standing that we found in Belgium versus Senegal, which is based upon a mere status as a treaty party in a case which concerns the obligations erga omnes partes. Accordingly, the applicant state is not always required to prove any damage or injury it has suffered in such proceedings. Now, I argue that this is clear from the Southwest Africa case in 1960 1966, which I wish to quote in full because it has been sometimes misunderstood. The court said this: in holding that the applicants in the present case could only have had a legal right or interest in the special interest provisions of the mandate, the court does not in any way do so merely because these relate to a material or tangible object, nor in respect of the conduct provisions does the court do so because any such right or interest would not have a material or tangible object. The court simply holds that such rights or interests, in order to exist, must be clearly vested in those who claim them by some text or instrument or rule of law. End of quote. Thus, it seems that the only debate which has divided authorities so far is on whether this kind of standing must be expressly stipulated in the treaty. Now, I found that since Belgium versus Senegal, the answer of the ICJ seems to be in a negative. The court has shown a very clear trend that it can now accept claims concerning breaches of obligations erga omnes partes, even without such express provisions in the relevant treaties. Now, of course, this is the reversal of the position of the court in the Southwest Africa case, but I finally argue that this new position is justified fully by state practice and policy consideration, in particular as evidence in the government comments to the International Law Commission and the positions or the arguments of Australia, India, Japan, the Marshall Islands, and the UK in recent cases before the International Court of Justice. I thank you for your attention.